Hello, everybody. I'm Athera Mathur, the Judith Bresler Fellow at the Center for Art Law, and I'm so happy to welcome you to the third Artist Legacy and Estate Planning Clinic of 2022. I would like to thank our network of volunteer professionals and attorneys without whom these sessions would just not be possible, and also for dealing with the numerous number of emails that I have sent them. Before I introduce our keynote speaker for today, let me let you know a little bit about the Center for Art Law and what we do. We are a Brooklyn-based research and education nonprofit, and we are dedicated to offering resources and programming so we can advance a vibrant arts and law community. We have our website, our newsletter, our events, and we try to disseminate information to keep our audience updated on everything art law, whether it's news, programs, cases, publications, and a lot more, including art law movies, podcasts, and even TV shows. We also hold clinical events such as ours today to connect artists and art professionals together to guide them in certain areas of the law. I would encourage you to take a look at our website, subscribe to our newsletter, and consider becoming a premium member to access our recordings and materials of past events and receive some exciting offers. We have a ton of very cool events coming up as well, including an art law conference at New York Law School in person and remote, which also has a panel on legacy and estate planning, apart from having a networking reception and even an art tour towards the end of the evening. We have a workshop on artist archives and a webinar on artist-gallerist relationships as well, leading to the launch of our new clinic, the Artist-Dealer Relationships Clinic, where we'll pair artists with attorneys regarding art contracts and consignment agreements. So you can see these and register for hopefully all of them on our website. A few housekeeping items. This keynote presentation is currently being recorded for archival purposes, but we would love to see you, so feel free to keep your camera on and microphones off. To those of you who have registered for the consultation sessions, we will begin at 6 p.m. and we'll assign breakout rooms for the sessions. After the event, I'll be sending across a handbook for the clinic that contains resources and additional reading materials on legacy and estate planning, including the bios of the professionals who are with us today, along with a recording of the keynote presentation. If you have any questions during the presentation, you can post them in the chat box below. Now, finally, let me introduce you to our wonderful keynote speaker for today. So we have Peter Caruso, who has been practicing in the area of art and law for over 25 years. He's practiced with Caruso and Caruso since 1996, with a brief period practicing at a Boston law firm focusing on intellectual property, media, and estate planning. Peter's represented local, national, international artists, gallerists, collectors, and his clients include individual artists and collectors. His work with volunteer lawyers for the arts offered an opportunity for Peter to co-author the Massachusetts Art Law Consignment Statute. So these are only a few things out of the many, many incredible things that Peter has done. So without any further ado, I'll let Peter begin his presentation. Peter, the Zoom screen is all yours.
Oh, thank you. All right, so here we go. I'm going to try, my 12-year-old will be praying for me to start the screen share, which I think, well, there we go. All right. All right. Well, good evening, everyone. Thank you for taking time to talk about something as exciting as estate planning. And it is something that is exciting and we should all be thinking about, frankly. My mom is an artist, and my father is the other partner in our firm here at Caruso Caruso. So I sort of have a unique perspective into looking at how to deal with artist estate planning issues, because as you all know better than I do, you've got the left brain and you got the right brain. This is my art. This is what I have so far. None of it's my own. But the left brain and the right brain don't often coexist well together, but they should in estate planning. I always like to think of estate planning for artists as sort of your final work of art, so to speak. It may not be your most celebrated work of art, but people are going to thank you for doing that. And the fact that you're here speaking about it now sort of is a testament to you taking that next step. And it's an important thing to do because most people, whether you're an artist or you're not an artist, you're just everyone else. There's this estate planning paralysis that happens out there. And you can look at a variety of different stats that will tell you why it happens and why it doesn't happen. You know, most people just say, I haven't gotten to it. There's more to that. I haven't gotten to it is I don't want to get to it. I don't want to talk about it. I don't want to talk about death. I don't want to talk about the stuff I have. I don't want to talk about the things I haven't done or the things that I want to do. All natural things to have in your mind. But as we'll see, and as you will see when you're in your breakout sessions, it's extraordinarily important to at least think about them right now. And I always like to tell artists, this is not the final set it and forget it type of scenario. This is a very workable part of your life that should change with you. And it's something you can think about every now and then. So it's not, I'm going to set it and then I can't touch it again. And I don't know what to do. So that's the prime reason is people sit around thinking, I haven't gotten to it for a variety of reasons. Other people think I don't have enough assets to set things up like a trust. And we'll talk a little bit about that here. And we'll talk a little bit about that, I think you will, in your breakout sessions. But a trust in a good estate plan should not be something that you think is relegated to the Rockefellers of the world. It's not. There are very important reasons why you should have certain estate planning documents in place that will help you and your beneficiaries down the line avoid sort of a catastrophe. And then other people don't do this because they don't know they have to. And then still others say it's too bloody expensive. The too expensive and they haven't gotten around to it are sort of the bookends of reasons why people haven't done that. And I think you should discard those right away because you're here, you've gotten around to it now, and you'll find that it isn't all that expensive. Now, estate planning can be a puzzle for people. It can be a mishmash of words. It can be a lot going on in your mind to say, all right, how many pieces of the puzzle do I have to put together? But what I want you to think about as you're going along here is you're going to be protecting yourself, protecting your legacy, and there'll be a slide later, protecting your beneficiaries, protecting your assets. And what are you protecting them from? You're protecting them from a couple things, but we can really narrow it down to just a couple. One of them is from estate taxes. If people say, oh, I don't have enough money to run into estate taxes. Well, I'll tell you, most artists, if they own property, real estate, if you have, investment accounts, 401ks, life insurance, anything along those lines, you add that together with your body of art, or if you're a collector with your collection, you might be approaching some estate tax thresholds. Now, federally, right now, you can each give away $12.06 million. And if you're married, it's over $24 million. Very few people say, I have an estate tax issue now. But if you live here in the Commonwealth of Massachusetts, it's $1 million. And $1 million sounds like a lot of money because it is. But if you add equity into your house or an apartment, life insurance proceeds, and other assets, you might be knocking on that door a lot faster than you think, especially as your legacy grows. So we have to think about, well, how do I manage that? You also have to think about how are you going to get your assets from point A to point B, meaning from your hands into your beneficiaries' hands. And I will tell you I preach to everyone, one thing we all want to avoid is the probate process. And that's being locked in probate court. And I used to say in Massachusetts does in fact have the oldest probate system in the country, and it acts like it. It acts like it did back when we had witch trials here in Salem, Massachusetts, right near where I live. It's old, it's slow, it's cumbersome. Put a COVID overlay on that, multiply that problem by 100. It is bad. I have some cases for artists and non-artists that have been in a probate court in Boston for 16 months. That used to take us maybe 2 weeks to get what we're trying to do. 16 months because they've either lost the file, they don't have enough personnel in there, they don't know what to do because they're new. You don't want to be at the mercy of the probate court. So there are different ways that we can look through that. And that in artists, in art collectors, and people in the art world, we all have a unique sort of set of rules that we have to think about because, visual artists, by, as you can see on my slide, by virtue of what you create, have a large and potentially valuable collection of work. My mom is an artist. My mom has thousands of pieces of work, literally, that are everywhere. And she's very attuned to this estate planning thing. But she always says to me and my brother, hey, you know what? When I go, pull up a dumpster and get rid of whatever you don't want. Well, that's not the best plan. So we're trying to fix that for her because, there are some pieces that other collectors have interest in, that museums have an interest in, that we might have an interest in, and the rest we have to figure out what to do in a responsible way. The other thing artists need to think about is you have that tangible property that you create, but you also have this intangible intellectual property that's out there that oftentimes is as valuable, if not more valuable than the actual work. So you have copyrights that you have to look at and you have to think about and you have to manage and you have to figure out who has what, where, when, and why. And the copyright law now has in effect since 2013 this thing called a termination right that we have to talk about in estate planning too. So you don't want to leave things on the table, and we'll get to that in a moment. And the last thing is you're probably leaving this property to someone, to anybody, and maybe wittingly or not, that either knows what's going on with your work, doesn't know what's going on with your work, or there's a third party that does that you haven't included in the plan. So we've got to think about all of these things as you're molding your plan. And are you putting the right people in place to understand and efficiently get your work from point A to point B? So there are many reasons, but three prime reasons that I've already mentioned here is we want to protect three things: your assets, your legacy, and your beneficiaries. We want to protect your assets from estate tax implications. We want to protect your legacy because if your artwork is there, you want to continue people's experience with your artwork, and you want to protect your beneficiaries. And I mean by that is if you leave an estate plan to someone who hasn't thought about what's going on and you haven't brought into the fold, it is going to be a horrible burden for those people. And they may not be able to handle the burden, or they may not be able to handle the burden in a way that you are actually hoping for. And this happens to everyone. And one example is Picasso. Picasso died with, depending on who you talk to, $500 million in assets on his death, or $1 billion. It depends on who you talk to, but we can all rest assured he had a lot of assets when he passed away. He had zero estate plan, not a single document in place. And as you can see by the slide, he left thousands of sculptures, thousands of paintings, even more drawings, tens of thousands of prints. All of these assets he left with no estate plan whatsoever. So what problems arise when you don't have an estate plan? Well, you have to figure out who gets what. Now, Picasso is a case study for estate planning attorneys because he had 4 children with 3 different women. He had a mistress who lived with him for decades, didn't have any children with her. Who gets what? And it took 6 years. And I wish I was an attorney on this, and I still don't understand this number, but it took 6 years, about $30 million in legal fees to wade through the estate. Now that's an extreme. I have no idea where the 30 million went over 6 years. That's a lot. But I can tell you, even the simplest of estates, if you have to go through the probate process and it's contentious at all, you are looking at thousands and thousands and thousands of dollars in attorney's fees that are unnecessary. And it may cause liquidation of some of the assets. It may cause the plan to go off kilter. It can cause family infighting. One of the grandchildren of Picasso didn't like the fact that Picasso's son, Claude, had sold a signature, an image of his father. They got into a lawsuit about that on who gets what, where, when, and how. But ultimately, it took at least 6 years, and that's pre-COVID. That was years ago, to get to the process. If you put that into play now, we would be talking double the years. So you hear me talk about this probate. I'm going to harp on it because now we can't, because it's born. Our prophecy is born true. The probate process is public facing. Everybody gets to see what you've done with all your assets, what assets you have, where they go, how much they're worth. The lawyers make out on it because it's costly. You have uncertain results. You have no idea who's going to get what, where, when, and how. frustrating delays. I have a client who's been very patient with me, but we've been stuck at the mercy of the court for 16 months, and we've done everything we can, but there's nothing that we can do. You have the risk of human error. You want to get out of that probate scenario. So you can probably talk in your breakout session about how do you avoid that. One of the ways you can avoid that is to set up a trust, set up a scenario where you're taking assets out of your name individually. So anything that you own individually on your death is a probate asset. That means it has to go through the probate court. If you set up a trust and place your assets into the trust, those assets become non-probate assets. You don't have to go through the court. You don't have to worry about it being publicly facing, and it's streamlined. You can actually get what you want to get done a lot quicker and more efficiently than you can through probate. It's a really important tool out there. And people shy away from trust because they think, oh, trust fund, and you automatically think billions of dollars. No. One of the prime reasons we set up trusts is to avoid probate, and it allows you the flexibility to have a huge roadmap as to what you want to do with your assets. And that roadmap can take any sort of shape that you want it to take. You can do pretty much anything that you want to within reason in there. But you can set that up. You can set up, appoint people, we call them cultural executors sometimes, or cultural trustees. They may be family members. They may be third parties. They may be collectors, people that you know, who know your assets well, who know your plans, that you can say, all right, Cousin John is good with money. Cousin John would be the trustee of the money. But, you know, my friend Mary is fantastic with my art, understands my art, understands what I want to do, understands the legacy I want to build, the relationships with my artists, my galleries, relationships with museums. And you can sort of bifurcate that trusteeship and have John take care of the money and Mary take care of your assets. So it's extraordinarily flexible, and you can change it. It's revocable. You can decide in 2022, this is my plan, but in 2026, things have changed. That's not my plan anymore. You can change it, but at least you have something in there that is going to pick everything up and dump it out of probate. So that's a prime reason you want to look at this. Another reason to start estate planning now is to inventory what you have. Now, some artists are extraordinarily good at that. They know exactly what they have, where they have it, and what's going to happen to their assets. They know exactly what artists' agreements are in place with galleries, whether they're consignment agreements or whether there's something else, whether it's a contract for sale or whether there's no contract. And believe me, there are countless of my clients who have galleries, who are the galleries of record for them, with nothing in writing, zero. And they've just been operating for 10 years on that. And I can tell you from experience, when somebody passes away and there's a bulk of their art is with a gallery, and I say, okay, we have to figure out now who owns what, that line becomes extraordinarily fuzzy suddenly. The gallery owner will say, well, no, these are mine. And when I sell them, I'll give a piece. And sometimes the estate is saying, no, we consign them to you. But in many states, if you don't have a written agreement for consignment, you may be out of luck on that. So this gives you a head start to get yourself organized. It also prevents what happened to Jasper Johns in 2013, while he was still alive, by the way. A former assistant of his was arrested and was sentenced to 18 months in jail. And I think he had to pay restitution of over $350,000 for stealing 2 of his works. And what his theory was, the assistant said, Jasper Johns gifted these to me. These are mine. I sold them. I made the money. And Jasper Johns said, I didn't do that. You were my assistant. And what it turns out had happened, he went in there, the assistant, went in there and created false inventory numbers and created this scheme where there was a gifting scenario that happened. Now, like I said, Jasper Johns was still alive, so he could actually say, I didn't do that. Those weren't my gifts. But imagine if he hadn't been alive, there would be a portion, millions of dollars, that had suddenly passed to this assistant without any consideration whatsoever as to whether or not that should have happened. So starting the process now allows you to inventory. It allows you to set into place who's getting what. And if the assistant was going to get something, fine. You could either make a lifetime gift or you could have made a gift at death. And there are different tax ramifications for doing that, and different tax basis ramifications for doing that you can discuss, with professionals or in your breakout groups. But there's oftentimes, it's often more advantageous to give something at death to the recipient there, because if you give it during life, the cost basis for that, if you're looking for a tax analysis, is the cost of materials. So if it only costs you the canvas and the paints, and then you gift it to someone, they turn around and sell it for $5 million, there's a very big difference there that the IRS will be thrilled to take a capital gain on. So you've got to start that process thinking about what you're going to do. And that gives you the opportunity to do this inventory, to look at the works you've created. What works have you kept? Where are they? Have you sold any gifts? Have you bartered any gifts? Do you have other artists' pieces in your collection? Do you have studio space that you need to think about, take care of? Do you have somebody who's going to be available to do an appraisal? What happens for storage when you pass away? All of these things you sort of have to think about right now. And I've mentioned consignment a couple times, but I can tell you here in Massachusetts, we have a very robust consignment statute that came into play because there were a lot of artists who didn't have planning in place. Boston Corporate Art was a gallery that used to take hundreds and thousands of pieces of work from artists in the local Boston area, and they used to consign those out to businesses. So if a law firm was looking for artwork, they'd go to Boston Corporate Art and say, we'd like that, please. And the law firm would be able to put that piece in for a fee in their law firm, and Boston Corporate Art would take some money, and then they would give it to whatever the commission is to the artist. But the problem is a lot of people didn't have consignment agreements in there. So Boston Corporate Art treated, as unfortunately some galleries do, treated this as a pyramid scheme. They'd bring money in, not even a pyramid scheme, it was just horrible accounting. They'd bring money in and say, oh, gee, all right, we got $15,000 in for this piece. The heat's due, my rent is due, and I have an employee I have to pay. I'm going to pay those expenses out of the $15,000. And then when I get the next payment in for one of my other artists, I'll take that money and I'll pay artist number one their commission. And they'd do that. And it would sort of be this sprinkle down effect. Well, it collapsed because ultimately it always does. They didn't have enough money to fill in the back apps. It was a Bernie Madoff type of scenario. And the whole thing blew up. But that left me and Jim Grace, who's chair of the Boston, or was chair of Boston Lawyers for the Arts, and now the Artists Cultural Council here in Massachusetts, and another attorney. We had to pick up the pieces, and we were in bankruptcy court for quite some time and bankruptcy court's crazy. Bankruptcy court with a lawyer for the bank who wore nothing, and this is how crazy it gets, nothing but Louis Vuitton everything, including his briefcase and his cane and his hat. He didn't care. He was in it for the money. And so he said, how can I make money on these consignment, these pieces of art that he said the gallery owned because there were no consignment agreements? And for the artists that had passed away, they said, no, those were given to us. And we had to sort that out. And we ultimately did. Ultimately, we came to a settlement where we were able to save about 4,000 pieces of art. But the real trouble was figuring out who owned what, where, when, and how. And if you had an estate plan and inventory in place, that would have been something that we would have been able to take care of very quickly, gotten the money, because there was a lot of money, and the artwork back to who we needed to get it back to. So it's important to think about that, to protect your assets, to protect your legacy. And a final quick point I want to talk about is this intellectual property, which is extraordinarily important and is often overlooked. The copyright, when you sell a piece of work, as many of you probably know, you can either sell it with the copyright or not, or retain the copyright for yourself. And many bill of sales don't say anything about the copyright, and that's fine for the artist, because if it's not in writing, it's not transferred. But you need to know that that's been retained, because that's value to you. That's value to you and your estate. That's value that can be exploited in advertising and whatever you want to use it for, forever and a day. I mean, when Elvis died, it wasn't so much copyright, but it was the trademark of his name. Priscilla Presley has made hundreds and hundreds of millions of dollars on the intellectual property of Elvis. And the Let's Get Ready to Rumble guy who did the Let's Get Ready to Rumble for all of the boxers, he made, and I only know this because I ran into a trademark suit. His lawyer called me because my clients were infringing on it. He makes $100 million a year on licensing. It's extraordinarily valuable. So you want to know where your copyrights are and who's getting them. And it's important, especially important now, because when the 1976 Copyright Act was put into place, they inserted this provision that allowed people to terminate license rights. If down the line you decided, you know what, I was a young artist at the time, I signed all my copyright to this gallery or to this agent because I didn't know any better. Sort of the Garth Brooks, I didn't make anything on my first album because they said, we don't know who you are. And by his fourth album, he told them how much he was going to make. So the Copyright Act was looking at this and said, if you've been taken advantage of maybe, you have the right to terminate that assignment. And every copyright holder has that. And in 2013, it started to pop into play. And you'd see people calling major movie companies and saying, I know I assigned the rights to that screenplay to you, but now I'm terminating it, please. And I get all the rights reverted back, which sounds wonderful. And you can sort of think, this is great. We can massage this and, as much as we can. But the termination rights come with the punch. Back in 1976, I don't know what they were thinking, but what they've done is they've created an automatic inheritance right for spouses, surviving spouse, and children or descendants of an artist. Automatic. So even if you've made this deal that you like during your lifetime, that you have no intention of terminating, if you do not provide for it in your will, has to be in a will, not in a trust, if you do not provide for the assignment of those rights to the people you want to have those rights to, the surviving spouse or descendants can blow up that plan. And they can come in and say, by virtue of the 1976 Copyright Act, we're hereby terminating the rights with you, gallery. We're hereby terminating the rights with you, agent. And you can have those rights revert back to your surviving spouse or descendants whom you might not have wanted to get those things. So you want to be aware of that because you want to take care of that through some planning. And there are different things that we can do in your will, specifically in your will, to make sure you preserve that copyright. But without knowing that and without sort of starting this process and thinking about what do we do? How do I protect these things? You can really cause some trouble for you and for your heirs. So some quick final thoughts as you go into these sessions. Think about avoiding probate. Think about how you want to inventory your assets. Think about where you want your assets to go. And then think about selecting a helpful fiduciary, somebody who gets it, somebody who knows what you want to do with your work, somebody who understands it, somebody who's going to push forward what your ultimate goals are. And that way you can have a holistic plan in place. And I'm quite positive that the people you're going to be speaking with will be able to get into the nitty-gritty details of some of the documents that are important: wills, trusts, powers of attorney. And now you're doing this estate plan. Think about healthcare proxies, what to do about your health decisions. Get that conversation moving so that ultimately, when it comes down to look at all of the wonderful work that you've created or you've amassed at the end of the day, you have a plan that stays private, that's out of the public eye, avoids probate, gets your assets, at least as a roadmap for a carefully selected fiduciary to get your assets from point A to point B. And this process, use it as a tool, not just for death planning, but for lifetime planning. Get everything in order. Get your contracts in order. Understand your intellectual property rights. Understand where your things are, where your artwork is consigned, and get that inventory done. And if you do that as the starting process, the end of this is going to be very valuable to you because you're actually going to take away something you can use today, and you're going to take away something that you can use continuing into the future. So that was a very brief overview in 25 minutes of artist estate planning and some of the bigger issues that you should look at. And I feel very confident you're going to get a lot of value out of these one-on-one sessions as you move forward. So thanks for listening to what is otherwise people like to shut off immediately about estate planning. And good luck to all of you.
Thank you so much, Peter, for that wonderful presentation. I think that was, it's given everybody a lot to think about. Before we begin, there are a couple of questions that we have lined up that may be helpful.
Sure.
So when you begin thinking about legacy and estate planning, who is the first person that you should try to get in touch with? Is it a lawyer, an appraiser? And when do you think is the best time to get in touch with a lawyer to begin planning for it?
Well, I'm a lawyer, so I always say lawyer, and I say that not just because I'm a lawyer, but I say that because if you find an estate planning lawyer who works with artists, we like to serve as sort of the wheel, and we have a variety of different spokes that we can reach out to. So we can help you with an appraiser, we can help you with somebody who can do a nice inventory for you, we can help you with an accountant. So if you start centrally, we can say, all right, let's talk about your plan. Let's talk about your assets. Let's talk about where you want to go. And then we can direct you. We almost want to shepherd you through that so you don't have to do that. If you start with an appraiser, you'll get that distinct piece done. But that may be all they say. They say, oh, all right, here's your appraisal. With the lawyer, we'll say, these are the pieces we need to appraise. You have assets. We got to talk to a CPA right now. You have all these contracts. We got to look at these contracts and see what you own. You have a lease. So I always say start with a lawyer, and I always say start with a lawyer. As soon as you start thinking, should I be doing estate planning? Yes, you should. And even before that, you really should, because like I said, this is a process that will move you not only at the end of life, but now. It'll help you now and get a hold of what you have, and then you can change it as you go.
Perfect. Thank you. Thank you so much for that, Peter. We also have a question from one of the participants who would like to ask on camera. So you can go ahead. Thank you.
Thank you so much. Thank you, Mr. Caruso, and everybody that's affiliated with this clinic who's worked really hard to put the event on. Mr. Caruso, you mentioned earlier that your mother saying something along the lines of, hey, just throw the pieces in the trash can, if you don't want them. And that made me think about oral agreements, specifically oral trusts. And I was wondering if you can speak about oral trust a little bit and to the extent that they are enforceable.
Yeah. So here's my take on oral trust. I don't like them. And the reason why I don't like them is because there's room for interpretation. Now, having said that, if you have a roadmap down in a trust, for instance, and you talk to somebody that you trust, your cultural executor, as I call the person, and say, this is what I want to have happen. And even you jot it down on a piece of paper or little notes on the side, while they're not legally enforceable in the trust, it helps govern your trustee, and it helps a third-party fact finder. If there's a dispute, a judge will look at it and say, well, how do I know what anybody really thought? Well, that testimony from somebody who said, I had this conversation, or here's a note that I was handed, is very valuable. I could tell you that oral wills, for instance, they don't exist. The only time you can have an oral will or a handwritten will is if you're on a sinking boat, is that's in the statute, or your life is in death. You can say, give your oral will to someone right before you die, or if you're sinking. So as much as you can get in writing, the better. I cannot tell you how many times people's good faith efforts have gone to waste because they've had these conversations and these quote unquote oral agreements that erode over time or change over time. So they're a nice component, but they should complement what you have something in writing.
Thank you very much. Appreciate it.
Thank you, Peter. I think we have time for probably just one more question. One of the participants has also asked, are there any circumstances where sometimes because of the legal fees and the expenses, all of the planning for the estate, would it outweigh actually beginning the planning process? Are there any circumstances where you think you should hold off on planning because of the expenses involved?
Yeah, no. Okay. And I'm going to tell you no, but I'm going to tell you there are resources that if you can't pay, like, volunteer lawyers for the arts, for instance, there are a variety of different resources that you can go to that have volunteers that will help you. It is so important that you start the process, that I would not wait until, you have the money. And it's really not as cost prohibitive as people think. Yes, it costs money. It just does. We know that. But the short answer is no, because, and I'll be brief on it, but let's say you have pieces of work that you don't think are valuable enough. Well, sometimes when we pass things, they become more valuable, or you have beneficiaries who know how to harness that value. If it's stuck in probate, it will cost you more money than it would have cost you, or you won't care, you're not around, but it will cost your estate and your beneficiary more money than it would have to plan. The simplest of estate plan, I had to go through probate for someone not an artist who had less than $25,000 in assets, no real estate, but we couldn't get into his apartment because they wouldn't let us in unless we went through probate. That's cost $2,500 so far. Okay, that's a lot of money, but it's necessary because we had to get in there, and the heirs wanted to pay it. But you can pay more money in probate than you would for planning. So no, I think it's a good idea to have something in plan, even if it's something simple.
All right, perfect. Thank you so much, Peter. We really appreciate you being here for your presentation and for answering all of the questions. I know I have a lot more in mind, but I see that we've already gone a little beyond the time.
Yep.
But we really appreciate it. And I think your presentation also sets a very strong base for the next part of the clinic. So thank you so much. And
my pleasure.
Yeah, in case any of the participants would like to get in touch with you later, would it be okay if I send across your email ID?
Yeah, please do. And don't look, if you guys have a question, don't think the clock is going to be ticking. I don't work that way. If you have a question after this and you call and say, this was bugging me, and you shoot me an email, I'm going to give you an answer. And if it's something that's I think is actionable for you, I will give you a roadmap. So please feel free to ask the question. I'd rather people ask the question than keep it inside. Just get it out there.
Thank you. Thank you, Peter.
Right. My pleasure.